Chapter 10. The Legislature. Part 1. Composition of Parliament. Article 93. The Parliament of Ghana. 1. There shall be a Parliament of Ghana which shall consist of not less than 140 elected members. 2. Subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. Article 94. Qualifications and eligibility. 1. Subject to the provisions of this article, a person shall not be qualified to be a member of Parliament unless a. He is a citizen of Ghana, has attained the age of 21 years and is a registered voter. b. He is resident in the constituency for which he stands as a candidate for election to Parliament or has resided there for a total period of not less than 5 years out of the 10 years immediately preceding the election for which he stands, or he hails from that constituency, and c. He has paid all his taxes or made arrangements satisfactory to the appropriate authority for the payment of his taxes. 2. A person shall not be qualified to be a member of Parliament if he a. owes allegiance to a country other than Ghana, or b. has been adjudged or otherwise declared 1. bankrupt under any law in force in Ghana and has not been discharged, or 2. to be of unsound mind or is detained as a criminal lunatic under any law in force in Ghana, or c. has been convicted 1. for high crime under this Constitution or high treason or for an offense involving the security of the state, fraud, dishonesty, or moral turpitude, or 2. for any other offense punishable by death or by a sentence of not less than 10 years, or 3. for an offense relating to, or connected with election under a law in force in Ghana at any time, or d. has been found by the report of a commission or a committee of inquiry to be incompetent to hold public office or is a person in respect of whom a commission or committee of inquiry has found that while being a public officer he acquired assets unlawfully or defrauded the state or misused or abused his office, or willfully acted in a manner prejudicial to the interest of the state, and the findings have not been set aside on appeal or judicial review, or e. is under sentence of death or other sentence of imprisonment imposed on him by any court, or f. is not qualified to be registered as a voter under any law relating to public elections, or g. is otherwise disqualified by a law in force at the time of the coming into force of this Constitution, not being inconsistent with a provision of this Constitution. 3. A person shall not be eligible to be a member of Parliament if he a. is prohibited from standing election by a law in force in Ghana by reason of his holding or acting in an office the functions of which involve a responsibility for or are connected with the conduct of an election or responsibility for the compilation or revision of an electoral register, or b. is a member of the police service, the prison service, the armed forces, the judicial service, the legal service, the civil service, the audit service, the parliamentary service, the statistical service, the fire service, the customs, excise and preventive service, the immigration service, or the internal revenue service, or c. is a chief. 4. For the purposes of paragraph d of clause 2 of this article, in the case of any finding made by a commission or committee of inquiry which is not a judicial or quasi-judicial commission or committee of inquiry, without prejudice to any appeal against or judicial review of that finding, the finding shall not have the effect of disqualifying a person under that paragraph unless it has been confirmed by a government white paper. 5. A person shall not be taken to be disqualified to be a member of Parliament under paragraph c or d of clause 2 of this article if a. 10 years or more have passed since the end of the sentence or the date of the publication of the report of the commission or committee of inquiry, or b. he has been pardoned. Skips articles 95 to 106. Article 106 Mode of exercising legislative power. 1. The power of Parliament to make laws shall be exercised by bills passed by Parliament and assented to by the President. 2. No bill, other than such a bill as is referred to in paragraph A of Article 108 of this Constitution, shall be introduced in Parliament unless A. It is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects of the existing law, the remedies proposed to deal with those defects and the necessity for its introduction, and B. It has been published in the Gazette at least 14 days before the date of its introduction in Parliament. 3. A bill affecting the institution of chieftaincy shall not be introduced in Parliament without prior reference to the National House of Chiefs. 4. Whenever a bill is read the first time in Parliament, it shall be referred to the appropriate committee appointed under Article 103 of this Constitution, which shall examine the bill in detail and make all such inquiries in relation to it as the committee considers expedient or necessary. 5. Where a bill has been deliberated upon by the appropriate committee, it shall be reported to Parliament. 6. The report of the committee, together with the explanatory memorandum to the bill, shall form the basis for a full debate on the bill for its passage, with or without amendments, or its rejection, by Parliament. 7. Where a bill passed by Parliament is presented to the President for assent, lie shall signify, within 7 days after the presentation, to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under Article 90 of this Constitution. 8. Where the President refuses to assent to a bill, he shall, within 14 days after the refusal, A. State in a memorandum to the Speaker any specific provisions of the bill which, in his opinion, should be reconsidered by Parliament, including his recommendations for amendments if any, or B. Inform the Speaker that he has referred the bill to the Council of State for consideration and comment under Article 90 of this Constitution. 9. Parliament shall reconsider a bill taking into account the comments made by the President or the Council of State, as the case may be, under Clause 8 of this article. 10. Where a bill reconsidered under Clause 9 of this article is passed by Parliament by a resolution supported by the votes of not less than 2/3 of all the members of Parliament, the President shall assent to it within 30 days after the passing of the resolution. 11. Without prejudice to the power of Parliament to postpone the operation of a law, a bill shall not become law until it has been duly passed and assented to in accordance with the provisions of this Constitution, and shall not come into force unless it has been published in the Gazette. 12. The provisions of clauses 7 to 10 of this article shall not apply to a bill certified by the Speaker as a bill to which the provisions of Article 108 of this Constitution apply, and accordingly, the President shall give his assent to any such bill when presented for assent. 13. Where it is determined by a committee of Parliament appointed for the purpose that a particular bill is of an urgent nature, the provisions of the preceding clauses of this article, other than Clause 1 and Paragraph A of Clause 2, shall not apply, and accordingly, the President shall give his assent to the bill on its presentation for assent. 14. A bill introduced in Parliament by or on behalf of the President shall not be delayed for more than 3 months in any committee of Parliament. Article 107 Retroactive legislation. Parliament shall have no power to pass any law. A. To alter the decision or judgment of any court as between the parties subject to that decision or judgment, or B. Which operates retrospectively to impose any limitations on, or to adversely affect the personal rights and liberties of any person, or to impose a burden, obligation, or liability on any person. except in the case of a law enacted under Articles 178 to 182 of this Constitution. Skips Article 108 to 114. Part 4 Privileges and Immunities. Article 115 Freedom of speech and of proceedings. There shall be freedom of speech, debate and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Article 116 Immunity from proceedings for acts in Parliament. 1. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be instituted against a member of Parliament in any court or place out of Parliament for any matter or thing brought by him in or before Parliament, by petition, bill, motion or otherwise. 2. Whenever in the opinion of the person presiding in Parliament a statement made by a member is prima facie defamatory of any person, the person presiding shall refer the matter for inquiry to the Parliamentary Committee on Privileges, which shall report its findings to Parliament not later than 30 days after the matter was referred to it. 3. Where the committee referred to in Clause 2 of this article reports to Parliament that the statement made by the member is defamatory of any person, the member who made the statement shall, within 7 days after that report, render an apology at the bar of Parliament, the terms of which shall be approved by the Parliamentary Committee on Privileges and communicated to the person who has been defamed. 4. Where a member refuses to render an apology in accordance with Clause 3 of this article, the Speaker shall suspend that member for the duration of the session of Parliament in which the defamatory statement was made, and a member so suspended shall lose his parliamentary privileges, immunities and remuneration, but they shall be restored to him if, at any time before the end of the session, he renders the apology as required by Clause 3 of this article. 5. A person who has made a contemporaneous report of the proceedings in Parliament, including a statement which has been the subject of an inquiry under Clause 2 of this article, shall publish the apology referred to in Clause 3 of this article or the suspension or the apology referred to in Clause 4 of this article with the same prominence as he published the first report. 6. If a person fails to publish the apology as required by Clause 5 of this article, he shall not be protected by privilege. Article 117 Immunity from service of process and arrest. Civil or criminal process coming from any court or place out of Parliament shall not be served on, or executed in relation to, the Speaker or a member or the clerk to Parliament while he is on his way to, attending at or returning from, any proceedings of Parliament. Article 118 Immunity from witness summons. 1. Neither the Speaker, nor a member of, nor the clerk to, Parliament shall be compelled, while attending Parliament, to appear as a witness in any court or place out of Parliament. 2. The certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament. Article 119 Immunity from service as juror. Neither the Speaker, nor a member of, nor the clerk to, Parliament shall be required to serve on a jury in any court or place out of Parliament. Article 120 Immunity for publication of proceedings. Subject to the provisions of this Constitution, a person shall not be under any civil or criminal liability in respect of the publication of a. the text or a summary of any report, papers, minutes, votes and proceedings of Parliament, or b. a contemporaneous report of the proceedings of Parliament unless it is shown that the publication was affected maliciously or otherwise without good faith. Article 121 Privileges of witnesses. 1. A person summoned to attend to give evidence or to produce a paper, book, record or other document before Parliament, shall be entitled, in respect of his evidence, or the production of the document, as the case may be, to the same privileges as if he were appearing before a court. 2. A public officer shall not be required to produce before Parliament a document where a. The Speaker certifies 1. That the document belongs to a class of documents, the production of which is injurious to the public interest, or 2. That disclosure of the contents of the document will be injurious to the public interest, or b. The National Security Council certifies 1. That the document belongs to a class of documents, the production of which is prejudicial to the security of the state, or 2. That disclosure of the contents of the document will be prejudicial to the security of the state. 3. Where there is a doubt as to the nature of a document such as is referred to in Clause 2 of this article, the Speaker or the National Security Council, as the case may be, shall refer the matter to the Supreme Court for determination whether the production or the disclosure of the contents of the document would be injurious to the public interest or, as the case may be, prejudicial to the security of the state. 4. An answer by a person to a question put by Parliament shall not be admissible in evidence against him in any civil or criminal proceedings out of Parliament, except proceedings for perjury brought under the Criminal Law. Part 5 Contempt of Parliament. Article 122 General Contempt. An act or omission which obstructs or impedes Parliament in the performance of its functions or which obstructs or impedes a member or officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament or which tends either directly or indirectly to produce that result, is contempt of Parliament. Article 123 Criminal Proceedings. Where an act or omission which constitutes contempt of Parliament is an offence under the criminal law, the exercise by Parliament of the power to punish for contempt shall not be a bar to the institution of proceedings under the criminal law.